Hey, folks, I got another update for you in United States v. Comey. We're having quite an eventful week in United States v. Comey. The docket has been active basically every single day. Plus, there was a hearing yesterday, and in that hearing, a bombshell was produced. And already made a video covering that. You can find it on my YouTube or on my Rumble, wherever you're watching this. I also have a new episode of my podcast that just came out this morning, if you're interested in getting into the details of the most recent filings in this case. But for this video, I want to focus on a late night filing that Lindsay Halligan made. That filing is in response to what happened in the hearing today. The hearing was in front of District Judge Nachmanoff, who is handling the Comey case and will be the man handling the trial. He was having a hearing on Comey's motion to dismiss for selective and vindictive prosecution. Now, that's a motion I don't think is going to be very successful. Neither does my dog Hercules. Doesn't think much of it. But what happened in the hearing was that Nachmanoff took the opportunity to ask Lindsay Halligan some questions directly about the grand jury proceedings. This is because earlier this week, a magistrate judge who's handling the matter of a filter protocol in this case, and also the matter of whether or not grand jury materials should be disclosed to Comey's team. Thank you, Hercules. Thank you. He made an order, and he made 11 findings, and he made an order to the prosecution that they need to turn over all grand jury materials in this case to Comey's team. That would be the transcript, an audio recording, and all the documents that they used. So Lindsay Halligan's team does not want to do that. They filed a motion right immediately afterward for an emergency stay. That goes to Judge Nachmanoff, who did award them an emergency stay of the order and told them to file their objections by the end of the week. Today, late last night is when her objections were due. They did file those. I'm going to make another video about that. But she also filed a clarification. That's this 7-page filing right here. And it specifically addresses what occurred before the grand jury. Now, there's been a big question, and like I said, I covered it in the other video. There's been a big question about how this grand jury proceeding was conducted. And the bombshell from the hearing yesterday was that the second indictment, which is the 2-count indictment, the one that actually did charge Comey, was not shown to the full grand jury. And Lindsay Halligan confirmed that only the foreperson and another grand juror were present when she presented that 2-count indictment to them. They were the only remaining members of the grand jury there, and they concurred with it. The foreperson signed it, Lindsay Halligan signed it, and then she filed it on the docket, officially charging James Comey with 1 count of false statements and 1 count of obstruction of Congress. So Nachmanoff pressed Halligan on exactly what happened in the grand jury. She spoke for less than a minute, apparently, according to reporters who were there. And the judge said, okay, I just wanted to make sure. Now, the hearing wasn't about this, but he took the opportunity to press Halligan on this specific issue because it's on his mind because of this order. The defense immediately seized on the moment and said, well, Judge, if she didn't show the indictment to the full grand jury, then there is no indictment. Which, I mean, on the face of how this has been going, it makes a lot of sense. You can't indict somebody based on just 1 or 2 grand jurors taking a peek at it. You got to show it to the full grand jury. And apparently that didn't happen. Well, or did it? I had said in the previous video that, man, the momentum is with the defense on this case. Things are not looking good for Halligan, and it looks like there's a big mess for DOJ to clean up here in this case. This filing right here goes a long way towards cleaning it up. And what this filing says is that, look, we had one presentation to the grand jury. one witness. It lasted about 2 hours. The presentation did. Ended around 4:30 p.m. on September 25th. The grand jury then deliberated for about 2 hours. They returned a no true bill, which means they failed to indict on count 1, but only on count 1. On counts 2 and 3, they concurred with an indictment. More than 12 jurors agreed that there was probable cause to indict James Comey on counts 2 and 3, but not count 1. So what happened next? Well, Lindsay Halligan made an edit. She took the 3-count indictment and she edited it down to a 2-count indictment. And then she changed the numbers from 2 and 3 to 1 and 2. She showed that to the grand jury foreperson. He concurred with it, and they both signed the new version. And then she went and presented it to in open court, filed it, and boom, James Comey was officially indicted with those 2 charges. According to Halligan's filing, Federal Rule of Criminal Procedure Rule 6 simply does not require a successive voting procedure where there is a mixed return from a grand jury on a multi-count indictment. Thus, the grand jury here passed the actual terms of the indictment, and that's consistent with Rule 6 of the Federal Rules of Criminal Procedure, which govern such things. Therefore, a dismissal on the grounds that the grand jury did not concur in the charges that were brought against Comey is not warranted here because they did concur. Supreme Court and Fourth Circuit precedent addressing changes to indictment also support the argument that nothing of improper occurred in this case. And the way Lindsay Halligan explains it in this order goes a long way to salvaging the situation, to recovering the dire strait she's in as far as the allegation that anything improper occurred in front of the grand jury or in the handling of the indictment. She says here, look, Judge Nachmanoff, you sought clarification as to what occurred before the grand jury, and the record shows that a duly constituted grand jury considered the presented indictment, the 3-count one, returned a true bill, meaning they concurred, more than 12 of them voted yes, there's probable cause to indict, on counts 2 and 3, but not count 1. Controlling Supreme Court precedent and Fourth Circuit precedent allow for a mixed indictment, a mixed return from a grand jury where some counts are voted yes and some counts voted no. It's allowable under the precedent for the US Attorney to remove the ones that were not found to justify probable cause to indict, remove those, redraft for the ones that were. And that's what she did. The constitutional function and purpose of the grand jury in all possible respects, therefore, was achieved, and the indictment stands. There is an indictment of James Comey. Do you agree? Hercules wants to be in this damn video. Is that enough? I don't know. But I think this goes a long way towards explaining what was Judge Fitzpatrick's in his order, in his memorandum and opinion that accompanied the order. This goes a long way to countering or maybe nullifying or overcoming, whatever word you want to use, the 11th finding. He made 11 findings and then his conclusion and order that grand jury materials need to be disclosed. And the 11th finding from his memorandum was the grand jury transcript and recording likely do not reflect the full proceedings, because although it is clear that a second indictment was prepared and presented to the grand jury, the transcript and audio recordings of the proceedings do not reflect any further communications after the grand jury began deliberating the first indictment. And that's where we have heard about the missing minutes. Judge Curry, who's the senior district judge who's looking at Comey's motion to dismiss for unlawful appointment of Halligan, also in a previous hearing, like a week or so ago, had asked the prosecution about the grand jury proceedings and had told them, it looks like there's missing minutes here because there's only one presentation on the record. There's only one presentation to the grand jury, and yet 2 indictments were produced. One that failed, the 3-count version, and then one that passed, the 2-count version. but there was only one session of deliberation and one session of presentation according to the records from the grand jury proceedings. How could that work? This is how. Halligan says this is how. She edited it. Is that allowed, guys? Can a prosecutor do that? The way she explains it in her filing, it seems like she can. She's got precedent to back it up from the Supreme Court, precedent from the Fourth Circuit. The rules don't literally say that the grand jury would have to go and look at it again, and it would have to be re-presented and re-deliberated upon. It makes a lot of sense to me. So I think that Halligan, at least as concerns this one point, this one irregularity that has been raised, I think Halligan has salvaged this situation. Well done. I also think that this case does not lack drama. We are on a roller coaster ride, and it's a lot of fun to follow this case. I'm very much enjoying it. Thank you for being here. If you haven't done so already, please subscribe, leave a like, a share, leave a comment as to what you think. Do you think that this recovered it? Does this make sense to you, that the prosecutor can do this? It's making sense to me. It's making sense to me. It'll be interesting to see what the defense's perspective is on this point. And it'll be very interesting to see what Judge Nachmanoff does. Because right now, he's looking at some things that could lead to the case being dismissed before Thanksgiving. Do I think that'll happen? I sure hope not. I'm having way too much fun following this case. So, all right, folks, visit my link tree, find all the places to follow, watch, and listen and support, and I will see you on the next video.